You just revise. In our what just now we have written, we have notes, right? So company having share capital. So one is equity share capital. Equity share capital, which is not a preference share capital, having voting rights, having voting rights, having differential rights. And what about preference share capital? Yeah, right now and in the future also carries and would carry what a preferential right with respect to dividend and repayment of capital, and with respect to dividend fixed amount on fixed percentage, which is either tax free or it is subject to tax, or it is the preference, the dividend is taxed. And what about repayment of capital? Either at the winding up or at the end of which term what they will repay. What will be the repayment amount? Either paid up share capital, or if they are repaying, if they are redeeming the preference shares at a premium amount, they can do yes or no. This may or may not be specified in the memorandum of association. Yes. Yeah. I forgot to discuss one more point. Provided that nothing contained in this act shall affect the right of the preference shareholders who are entitled to participate in the process of winding up before the commencement of this act. So what is this, sir? Sir, before this commencement of this act, which means before the company got incorporated. Company got incorporated when Companies Act 1956 was there, when 1990 Companies Act 1956 was present, the company was incorporated. Let's say the date of incorporation is 1st January to 1991. 1st January 1991. Yes or no? Yes. No. Now the year is now the year is 2019. Now the year is 2019, and it is now winding up is taking place. Winding up is taking place. Okay. In this one, and now because the company was incorporated when Companies Act 1956 was Companies Act 1956 was present, do preference shareholders have preferential rights, which has been specified in Companies Act 2013? Do they have preference share? So when they got incorporated on 1st Jan 1991. That is when Companies Act 1956 was present. But this is when it is wound up, it is being wound up on 2019. Okay. So my question is, as per Companies Act 2013, do preference shareholders have preferential rights as per Companies Act 2013? So is this being affected? No, it is not being affected. Yes, they have the preferential right. Even though it got incorporated, during the period of Companies Act 1956, not on or after 1/4/2014, which is not on, not with respect to Companies Act 2013 it got incorporated, but Companies Act 1956, even still preferential right with respect to dividend and repayment of capital will be there. Yes. What is called as deemed to be preference share capital? What is called as deemed to be preference share capital? Dividend. What dividend for the one with respect to dividend? Surplus profit. Preference shareholders has a right to participate either fully or to a limited extent. Next, repayment of capital. After entire share capital is paid, some surplus amount is remaining. Preference shareholders has a right to participate. Either fully or to a limited extent. Yes or no? Yes or no? Yes. So this is what is section 43. No. So section 43 Section 43 shall not be applicable to. Section 43 shall not be applicable to whom? Private company, specified IFSC, public company. So private company and specified IFSC company, public company, section 43 is not applicable. No, not like that. Where memorandum or article of association so provides. Sir, unable to understand. Where memorandum or article of association provides for it. Unable to understand. See, where private company or IFSC public company. What are they saying? What are they saying? That in their memorandum or articles, they are exempting section 43, which is this is not applicable. They are saying this section 43 is not applicable. Then in that section, in that case, private company or IFSC public company is not applicable. So what if memorandum or article didn't say? What if memorandum or article is not specifying? It's not specifying about this section. Then private company and IFSC public company has to comply section 43. Has to comply section 43. Okay. But there is one more condition for private company. If you want to avail this exemption. If you want to avail this exemption, of course, in MOA and AOA, in MOA or AOA, you have to provide this. Along with it, exemption shall be applicable to a private company which has not committed default in filing financial statement or annual return with the registrar. So, financial statement and annual return has to be filed with the registrar. So, what if financial statement or annual return has not been filed? Simple. Section 43 will be applicable even if MOA and AOA specifies that it is not applicable, but a financial statement or annual return has not been registered. Then what? They are not filed. Then what? This particular exemption is not applicable. Private company has to comply section 43. Yes. So now, so it's also well, yeah. So what are we gonna see? So first we will revise the rule for equity shares with differential rights. After that, we'll start with section 46. Equity shares with differential rights. This so when will you issue equity shares with differential right? Only if the following conditions are satisfied. What are those conditions? First is for the one article should authorize, and if it is a listed company, an ordinary resolution should be passed in a superb through postal ballot. And how about if it is an other than listed company? Superb. Ordinary resolution should pass in a general meeting. Yes. Voting power should not exceed 75% of the total voting power. Superb. And what if following defaults shall not be paid? What are the following defaults which should not be paid? One, company should file with the registrar its financial statements and annual return. What if it didn't file? It's very simple. In the immediate in which financial year you want to issue equity shares with equity shares with differential rights. You have to see in the preceding 3 financial years whether there is this default. If there is this default, you cannot issue. Next, company when company is issuing this equity shares with differential right, is there any subsisting default? Is there any of these following subsisting default? If it is there, then you cannot issue. So what are those default? One is payment of dividend. Next is repayment of matured interest and matured deposit and interest. Next is redemption of preferences. Next is redemption of debentures and its interest. And how about company where what default has made in these following cases? If company has made default in these following cases, then only after making this default good, and 5 years you have to wait. After that only you can issue what? Equity share differential. What are those? Respective default? One is payment of dividend of preference shares. Next is repayment of term loan and its interest. Next is statutory payment of its employees, and next is defaulting crediting to investor education protection fund. Sir, yes. Next, court or tribunal has penalized whom? Company for what? if they have committed any offense with respect to these acts, what are those acts? One is RBI Act, next is SEBI Act, next is SCRA Act, and next is FEMA Act. Yes. And how about if then if they commit any offense and the court or tribunal has penalized them, then it is as if they cannot issue equity share differential rights? Not at all, not at all. What you have to wait for 3 years, which is from this current year, from the year where you're gonna issue differential rates. You have to see the last 3 years. You have to see the last 3 years whether court or tribunal has penalized with respect to these offenses. If that is the case, you cannot issue. Yes, yes. Then what? Then these are the following conditions you have to satisfy. Then only equity shares with differential rights can be issued. After that, company has to what? Annex what? An explanatory statement with the notice. After that, company shall not convert. What company shall not convert? Its existing equity shares into its existing equity shares with voting rights into equity shares with differential rights, and vice versa also they cannot convert. Yes or no? Yes. Then board of directors should disclose what in its board report about the equity shares with differential rights. But when will the board disclose? Only on completion of the equity shares with differential rights. After the company shall mention the register of members. This is what we have seen in rule 4. Sir, yes or no? Yes. So let's do the revision. So share certificate if company is issuing. If company is issuing a share certificate, it will be what? It will be in form number. It will be in form number as such one. Yes or no? Who will it? No. Will it have a distinctive number? Yes. Will it specify? In whose favor? Shares have been issued. Will it specify that? Yes. Shares to which share capital relates, whether it's preference shares or equity shares. Will it specify that? Yes. What is the paid up value? Will it specify that? Yes. It will specify that. Yes. And the share certificate issued is a prima facie evidence as to title of person to such shares. So yes or no? Yes. So share certificate, who will sign it? Who will sign the share certificate? One is two directors or one director and one company secretary. If company appoints the company secretary, yes or no? So yes or no? Yes. So about in case of one person company, director and company secretary or person authorized by board. So yes or no? Yes or no? Yes. Sir, how about common seal? It is optional. Whether you can you can do it or you cannot do it. You don't have to. And it is affixed. The common seal is affixed. If it is being placed, common seal is being placed. It is affixed in presence of persons. Who signed the certificate? Who signed the share certificate? Yes or no? Sir, yes or no? Yes. Next is facsimile. Facsimile signature. This I hope you guys know what is facsimile signature. Yes or no? Yes. Next is duplicate share certificate. So when is duplicate share certificate being issued? First question, form number, super form number SS2. When it is issued? When it is destroyed or lost. This has to be proved. This has to be proved that it has been destroyed or lost. Then only you can get a duplicate share certificate. Or else it has been defaced, mutilated, torn. Yes. This has to be, this share certificate, if it is defaced, mutilated or torn, it has to be surrendered. It has to be surrendered. Yes or no? Central government prescribes. Manner of issue. Manner of issue of share certificate. Manner of issue of share certificate or duplicate share certificate. Form, which form? SH1 or SH2. This has been prescribed by whom? Central government. Central government will prescribe what is the form number of it, the share certificate, and what is the form number of duplicate share certificate. Yes or no? Sir, yes or no? Particulars to be entered in the register of members. Particulars to be entered in the register of members or other particulars. This and all what CG can prescribe. Yes or no? Yes. No. Rule 5. Rule 5. If company is having a share certificate and what if it is having if company is having share capital, company is having share capital, what it can issue shares. If it issues shares, what? If it issues shares, then what? It has to issue share certificate. Yes, this will happen only when two of these conditions are satisfied. What are the conditions? One is board resolution is passed. Board resolution is passed. Next is something has been surrendered. What will a shareholder surrender to the company? What will shareholder surrender to the company? Tell me, sir. Letter of allotment or letter of acceptance or renunciation. What is this letter of acceptance and renunciation? This is in case of right issue. This is in case of right issue, sir. Yes or no? Sir, yes or no? Yes. No. So what if letter of allotment is lost or destroyed? What if letter of allotment is lost or destroyed? We saw that you have to what? You have to pass a board resolution. Letter of allotment should be surrendered. But before surrendering to the company, letter of allotment is lost by or destroyed by the shareholder. Then what should we do? Board shall seek supportive evidence. Board shall seek supportive evidence. So what is this, sir? For example, board gave that it has been allotted, but we have to know whether this is that person or not. So that board will ask, give me your political details such as bank details, so that you made the payment. How did you? So all those information will be asked. Yes, few support and next is indemnity bond. Indemnity bond. This we will also see where contract tag yes or no. Next is out of pocket expenses. For investigation for investigation made by company. For investigation made by the company who would have incurred out of pocket expenses. This has to be reimbursed to company. This has to be reimbursed to the company, yes or no. Next is, sir, we saw about signature, but facsimile. We will also see facsimile signature. We didn't revise it, yes or no. Director or company secretary. What? The signature will be deemed. Signature will be deemed to have been signed. Deemed to have been signed. When? If it is a facsimile. If it is a facsimile signature. How? So what's a facsimile signature? Means either by machinery or by equipment, either by machinery or by equipment or by other mechanical means. Either by machinery, equipment or other mechanical means, it has been engraved. What has been engraved? So what has been engraved? The signature has been engraved in a metal or lithography or digital signature. Yes. So this particular machinery, equipment or other mechanical device will what? Will help director or company secretary do their signature instead of the director or company secretary themselves does the signature. This has to be what? This has to be safeguarded. This has to be safeguarded by director or company secretary. Why? Why? Because they are permitting it. Director or company secretary is permitting it. Permitting facsimile signature. They are permitting facsimile signature, so they have to safeguard this what they have to safeguard this machinery equipment or other mechanical devices. Yes or no? Yes. where a share certificate has been issued, then in the register of members, few particulars has to be entered. Which CG will prescribe, and it will also mention also the name of the person in whose favor shares has been issued, and the date of issue of such shares. Sir, yes, sir. Yes. Next is rule 6. We saw rule 5. Next we are going to see rule 6. Yes or no? Yes. In case of deface, mutilated, torn, or old share certificate, shareholder want a duplicate share certificate. Shareholder want a duplicate share certificate, then this which shall be issued by company, shall be issued by company only when will it be issued? What are the conditions? What are the conditions? Superb. One, it has to be surrendered. One, the old certificate has to be surrendered, yes or no, and company will charge some fee. Company will charge some fee as board may thinks fit, as board of directors thinks fit, but not exceeding rupees 50. Yes or no? Sir, yes or no? Next is, what if share certificate has been lost or destroyed? Then in that case, it will be issued. It will be issued only when a board resolution is passed. Next, fees has been charged as board of directors thinks fit, which is not exceeding rupees 50. And what you have to furnish? You have to furnish what? So what you have to furnish? So tell me what you have to furnish. One is indemnity bond. Next is supportive evidence. So this and all we know now, sir. This and all we know, right? So by the way, I'm going fast, but I hope you guys know this. Now, if it got what? Duplicate share certificate has been issued. When in case what it is defaced, mutilated, torn, yes, it will be surrendered and company will charge some money. But if it got what? But if it got destroyed, then in that situation what to do? Or it got lost. Yeah, what a board resolution have to be passed. A fees what will be charged as both things fit. Then your company will also what shareholders should furnish to the company what an indemnity bond and some supportive evidence. Yes, and also out of pocket expense. Reimburse to company out of pocket expense. incurred by company while investigating. Incur for investigation. Incur for investigation. Sir. Yes. Duplicate share certificate, either if it is lost or destroyed, or if it is torn, mutilated, or worn out. Either of these cases, what you have to enter, how you entered when you issued a share certificate, the same way you have to enter in the register of members for duplicate share certificate also. Under section 88, yes or no? Yes. This I forgot. No. Before this, I want to put another point. Shall state on face of share certificate that this share certificate is a duplicate share certificate. Next. This duplicate share certificate, where it has issued, duplicate share certificate, if issued, have to be entered in register of members. And also have to be entered immediately, where in the register of renewable and duplicate share certificate. Yes, you will also, you will enter in the register of member, next you will enter in the register of renewable and duplicate share certificate. This duplicate share certificate first, what will it have? What will it mention? In this duplicate share certificate, what will it mention? One, name. Next, number of shares. What and all it will mention? Name, number of shares. Next, changes made in register of members. Changes made in register of members. Next is date of issue of duplicate share certificate. Yes or no? Yes or no? Yes. And who will authenticate it? And who will authenticate the share certificate? Superb. One by company secretary, or if it is either company secretary will authenticate it, or a person authorized by board. A person authorized by board of directors. Sir, yes or no? Sir, yes or no? Yes. Sir, understood, right? Duplicate share certificate, whether it is either lost or destroyed, or if it is torn, mutilated, or worn out, it shall state on the face of the share certificate that this is a duplicate share certificate, and also it has to be issued. What it has to be issued? If it is it has to enter. It has to enter in the register of member. Also, it has to enter in the register of renewal and duplicate. Yes, renewal and duplicate share certificate. Renewal and duplicate share certificate. What it has to mention? The name, the name of the person in whose favor shares has been issued. Next, number of shares issued. Next, change made in the register of members. What change, sir? What change has been made? That earlier it was issued. Next time it has issued a duplicate shares certificate. Any remarks has been made in the register of members. All those details will be mentioned here also. Next, date of issue of duplicate shares certificate. All these mentioned will be mentioned, and who will authenticate it? Who will sign, okay, this changes have been made and these changes are correct? Who will authenticate it? Company secretary or person authorized by the board? Yes or no? Yes. Next. Fourth one, duplicate share certificate. If it is issued, if it is what? If it is an unlisted company, it will be issued within 3 months. But if it is a listed company or if it is a listed company, it should be issued within 45 days. Within 45 days. So 45 days from when, sir? From date of submission of complete documents. So, sir, next. Register. Where will you keep the register? Where will register be kept? Where will register be kept? Either where it be kept, sir? It will be kept at the registered office or any other place where register of members is situated, is kept. Yes or no? Yes. And this register, what is this register, sir? What register it is talking about? Register of renewal and duplicate share certificate, yes or no? This register is register of renewal and duplicate share certificate, and this has to be permanently preserved by. This has to be permanently preserved by. Who will preserve it? Director or company secretary or person authorized by board. Person authorized by board, yes or no? Yes. So that's all, sir. So what is section 47 talking? Every equity shareholder shall have right to vote on every resolution placed before the company. Yes or no? Any class of preference shareholder, any class of preference shareholder whose dividend has not been paid for 2 years or more. So any class of preference shareholders whose dividend has not been paid for 2 years or more, what has a right to vote, has a right to vote on every resolution placed before the company. Sir, yes or no? Sir, yes or no? Yes. Every preference shareholder shall have a right to vote in the following cases. What are the cases? Resolution which directly affects his rights attached to preference shares. Yes, any resolution for winding up of the company. Yes, resolution for a reduction of share capital. Sir, this we will study in section 66. Sir, yes, sir. Yes, sir. Yes. In case of voting by poll, every equity shareholder and preference shareholder Sir, I'm really sorry for my handwriting. I'm really sorry for my handwriting. I can't focus both like handwriting and trying to explain. I can't. Okay. Shall be in. Shall be in proportion to. Shall be in proportion to super. Shall be in proportion to paid up share capital. Sir, yes, sir. Yes. So and we have seen the exemption. What private company, IFSC public company, if MOA or AOA so provides. If so provides, section 47 is not applicable. If MOA or AOA so provides. Plus also no default in filing its financial statements and annual return with registrar. Yes. So this is what we have seen. This is what we have seen. Yes or no? So what are we going to see, sir? Sir, we are going to first revise section 48. Yes. Yes. So what is section 48 talking about? Rights attached to variation of shareholders' rights. Yes. Right attached to any class of shares may be varied. Yes or no? Yes. How it first can be varied? Yes. If variation is contained in the memorandum or articles of association, If variation is not contained in the memorandum articles, then terms of issue of such shares where they have not prohibited for the variation, then you can what change you can change the shareholders right. We have seen when can we change the shareholders right or not? We discuss about that. Now we are going to discuss how can a company vary shareholders right? How can they vary? Either by passing a special resolution in a separate meeting or consent in writing by at least not less than three-fourths of the issue of such shares. Yes or no? Yes. Now, if and now either dissenting shareholders by way of special resolution or three-fourths of the case, one-fourth of the case. In either of the situation, these dissenting shareholders who is holding at least 10% of the shares, what can make an application to the tribunal. When will they make this application? Within 21 days. Within 21 days, yes or no? Yes. So why are they making the application? Please for the varying of the shareholders' right to be cancelled. For that they are making an application. Yes or no? Yes. And until the decision is made by whom? By the tribunal, no effect of variation can be made. Yes or no? Yes. So decision of tribunal, what decision will be made? Either tribunal will accept the application or reject the application. And this particular decision will be binding on all the shareholders. Yes or no? Yes. And this is what we have seen. Next. So variation of right of one class of shareholders, if it is affecting the other class of shareholders, what? Should give a consent. Should give a consent, then this particular variation is fine for us. This particular variation is fine for us. Then only the variation will apply. If the consent is not received, then the variation will not apply. Yes or no? Yes, sir. Section 49. Any call on shares of same class for further share capital shall be made only on uniform basis of same class. Sir, yes or no? Yes. No. What is different class mean? What does different class mean? For this section, for this section, shares on which nominal value is same and paid up value is different. This is called as what? This is called as different class. Yeah, yeah. What does section 50 talk about? Calls in advance. So company may accept from any member what? Whole or part of unpaid share capital if article of association authorizes it. If article of association authorizes it. Yes. for the part of the amount not called up. For the part of the amount not called up. This is called as what? This is called as calls in advance. And this calls in advance is non-refundable. Then one is it's not refundable. Next is what, sir? Next is interest. We'll talk about interest. Interest. Either article of association will mention, or it is agreed. It is agreed between board of directors and member. It is agreed between board of member and table F says that it should not exceed 12%. It should not exceed 12%. Yes or no? So yes or no? Yes. No voting power for calls in advance made. No voting power for calls in advance made. Yes or no? Yes. In case of winding up, calls in advance plus interest paid before calls in advance and interest paid before payment of share capital and after payment of creditors. So yes or no? Is there any other point I have to write? No. This is the point, yes. So next section 51. What is section 51 telling? Dividend may be paid in proportion to paid up share capital. If authorized by article of association. If authorized by article of association. Yes, sir, yes or no? Sir, yes or no? Yeah. Yeah. So what are we going to see? Yeah. So what are we going to see, sir? First, we'll revise section 52 and 53. So what is 52 talking about? Premium. Yes, issue of chase the premium. Okay, premium mean, what does premium mean? What does it mean? Issue price is more than face value. And what is the amount of premium? Difference between issue price and face value. So this amount of premium can be received either in cash or otherwise. And sum equal to the aggregate of premium amount. How will you calculate sum equal to aggregate premium amount? Number of shares into the premium amount. The premium amount. This amount, total this amount will be transferred to securities premium account. Okay. So now the amount, this particular amount is transferred to security premium account. Now when can we use this securities premium account? BEPS, basic economic price. B. What is B? Bonus shares. Is fully paid bonus shares. Or another B is buyback, which is purchase of its own shares. Yes, yes. Next is E. What is E? Write off. What write off? E. What is E? Expense. Expense to be written off. What expenses? Any issue of shares or debentures. And next is P. What is P? Write off of preliminary expense. And what is another P? Write off of premium on redemption of preference shares or debentures. Yes or no? Yes. And next, class of companies which CG has prescribed and the financial statement has been prepared as per accounting standards. Yeah. Yes. This particular class of companies, what to do? How can they use the securities premium account? Yes, they can use in three ways. One is fully paid bonus shares. Next is buyback. Next is expense on issue of equity shares. Okay, good. Next, section 53. What is section 53 we're talking about? Discount. Yes, discount. What is discount means? Issue price is less than face value. So the difference is the discount. Yes, can company issue shares at a discount? No, company shall not issue shares at a discount. If company is issuing shares at a discount, what is it? It's void. It's void. Yes or no? Yes. And company fails to comply this section. What does that mean? The company is issuing shares at a discount. Then is there any consequence? Yes, there is a consequence. What is the consequence? One, company. I forgot to mention it. Company and officer in default will make what will pay penalty or what amount range of 5 lakh whichever is less, and company will pay refund. Company will pay refund how much or money what which company has received along with the 12% per annum interest. Yes or no? But this with respect to discount there is an exception. Exemption. What is the exception? That issue of sweaty equity shares. This is what we are going to discuss now. Sweaty equity shares. Okay. Issue of sweaty equity shares which is mentioned in section 54. Also, company can convert the shares into company can convert the debt into shares. So company what is debt? Company has to give the amount to the company has a liability. Company has a liability that is called as debt. So company is giving some amount to that person. What do we call that person as creditors? Yes. So the debt is converted into shares. So company will pay shares to whom? To the creditors. Yes or no? Yes. Company will pay the shares with by two schemes. One is statutory resolution plan. Next is debt restructuring plan. And this particular plan, whose direction, guidelines, and regulation is made by RBI under RBI Act or Banking Regulation Act. So, this. Earlier, what we have seen section 4. Now we have to see rule 8. But we'll revise once more section 54. Okay. What is section 54? I'm saying. First, we'll start with section 2, clause 18. What is that? Equity share. What is equity share? Equity shares are issued by company to its employees or directors at a discount or for consideration other than cash. For what? For providing know-how or for making available rights in the nature of intellectual property rights or any value addition. What is value addition? Any economic benefit which is derived or to be derived by the company from an expert or professional for providing know-how or intellectual property rights. For them, company will give what? Yeah. So sweaty equity shares. But if remuneration is being paid for doing normal remuneration is being paid for doing this, giving providing know or intellectual property rights, then for those particular employees or directors, company will not issue sweaty equity shares. Yes, yes. And who are these employees? As per this section, employee means a permanent employee or a director, whether in India, outside India, a whole-time director or not a whole-time director. Next is an employee or director who's working in a subsidiary company or holding company. Okay, company may issue equity shares. Yes, only if the following conditions are satisfied. What are the conditions? One is it should be of same class. Already that particular class has have already been issued. One, two. A special distribution has been passed. Okay. Three. Equity shares. Equity shares where it has been listed. It has been listed in recognized stock exchange. Then SEBI regulation has to be followed. But whereas it has not been listed, then you have to follow CG rules. Rule 8. That rule 8 only we are going to see. And resolution must specify what number of shares, what is the current market price, and if employees or directors are giving any consideration and also class or director of employees. Yes, and right limitation, restriction, provision which are applicable to equity shares are also applicable to sweat equity shares, and holders of sweat equity shares shall rank pari passu with the other equity shareholders. Yes or no? See what we are going to see next. So section 54, what is it saying? It's talking about sweat equity shares. Yes or no? Yes. Equity shares, if company is issuing to its directors or employees either at a discount or for consideration other than cash, will it be issued to every person? No. It will be issued only for those who are providing know or those who are making available rights in the nature of intellectual property rights or those who are making any value additions. Yes. So what is value addition? Any economic benefit which company is deriving in the future or which is actually company is now deriving that particular benefit is being from a professional or a expert, which means director or employee is a professional or a expert who's providing know-how, intellectual property rights. For them, company will issue what sweat equity shares, but not those employees for whom consideration is received for consideration is received for providing know-how or intellectual property rights. Yes or no? Yes, sir. Who's an employee, whether permanent employee in India, outside India, director, whole-time director, not a whole-time director, employee or director who is working in a subsidiary or holding company. Next, notwithstanding anything contained in section 53, company may issue what? Company may issue is equity shares. Yes, company will issue equity shares if only following conditions are satisfied. What are the following conditions? One is a company should issue that shares which have already been issued. One, two, authorization is required. Authorization is required. What kind of authorization? A special resolution. Next, equity shares. If it is listed, if the equity shares is listed, you have to comply SEBI regulation. If equity share is not listed, you have to comply say central government rules, which is Rule 8. That also we discussed. The resolution must specify what name of shares, what is the current market price, what is the if there is any consideration received, and next is class of directors employees to whom equity shares are issued. Next is what's the rights, the limitation, restriction, provision which is applicable to equity shares are also applicable to sweat equity shares. Yes or no? Yes. Next. For how holders of sweat equity shares will rank pari passu with other equity shareholders. Rule 8. Rule 8. Rule is applicable to whom? Unlisted company. Yeah. Allotment of sweat equity shares shall be made within a period of 12 months from date of passing special resolution. Yes. What is the limit? What is the limit? Company issuing equity shares should not issue more than what 15% of the existing paid up equity share capital or 5 crores value, whichever is higher. Yes, this is in a year, but at any point of time, 25% of the paid up equity share capital should not be exceeded. Yes, and in case of startup company, the startup company may issue 20 equity shares. That startup company may issue 20 equity shares, but it should not exceed up to 10 years from the date of its incorporation. 50% of its paid up equity share capital is or no is. Next, lock-in. So equity share, if it is issued to employees or directors, it should not be transferred. It should not be transferred for a period of 3 years. For a period of 3 years. And this particular fact should be mentioned in the share certificate. What? It should be either in bold or in any prominent manner, the way that shares are either in law, shares are in lock, and what is the period of expiry and what is the expiry date for, so that directors or employees can transfer the shares. That should be mentioned in the share certificate. And valuation. So equity shares are to be valued by whom? By registered valuer. Yes, registered valuer at what price? At fair price. Yes, for the justification. And valuation of intellectual property rights, know-how, and value additions. Value addition shall be valued by whom? By a registered valuer. By a registered valuer giving justification for such valuation. Yes, and treatment of non-cash consideration. Treatment of non-cash consideration. Oh, the treatment, if the amount, if there is no amount received by the company, then how will company treat that consideration? If it is forming part of tangible or amortizable asset, then it will be carried to balance sheet. If it is not forming part of tangible or amortizable asset, it will be expense of the profit and loss account. Yes or no? Next. Explanatory statement will be annexed to the notice. Yes, explanatory statement, because this is not an ordinary business. This is a special business. Next. A board of directors will disclose board's report. Board of directors will disclose in the board's report. Yes. Next, register of certificate shares will be maintained in form number SS3 and it will be entered immediately. On issue of swell equity shares, and it will be authenticated by company secretary or any other person authorized by the board. Yes, sir. Yes. What is section 56 talking about? Transfer and transmission of securities. Okay. Transfer deed. Transfer deed. Lawmakers said it as instrument of transfer. Yes. And this is in form number SS4. This transfer deed, it should do a few things. Who should do a few things? Transferor and transferee should do few things. What it should be? It should be stamped. It should be dated. But what should transferor and transferee do? They should sign it. Which is they should execute it. Lawmakers told us as execution. Sign means execution. Okay. So after preparing transfer deed, transfer deed along with share certificate you have to shall be submitted. You have to submit. Transfer deed along with share certificate you have to submit. Okay. Submit to whom? Submit to the company. You have to submit to the company. Sir, yes or no? Yes. Now, when you have to, is there any time limit for? Is there time limit for Is there time limit for transfer deed and share certificate to be submitted to the company? Yes. It should be submitted within 60 days. 60 days from date of signing. Which is date of execution. Date of preparing the transfer deed. Yes. Sir, who can give this? Who can give this to the company? It can be submitted either by transferor or it can either be submitted by transferee. Sir, yes. But in case share certificate, we have to give share certificate along with the transfer deed. Yes, but the share certificate is not in existence. The share certificate is not in existence. How will share certificate not in existence? We know that company will give what? Company will give share certificate to shareholders. Now, how can it not be in existence, sir? It's very simple. If company want to give share certificate, company first will give a letter of allotment. Okay, to the shareholder. This particular letter of allotment, shareholder has to give it back to the company. Yes, after giving this back to the company will give a share certificate. So this and all when we are discussing share certificate, we have discussed yes or no. Yes, but the thing is yes, company has given the letter of allotment, but company did not. But shareholder did not give the letter of allotment back. If shareholder did not give the letter of allotment back, would share certificate be given by company? No. Yeah. So So let's say the share or even the letter of, okay. So what to do? What to do? What is shareholder having? But what is shareholder having? So the shareholder is having the letter of allotment. So letter of allotment shall be submitted. Shall be submitted along with the transfer deed. Along with the transfer deed, letter of no. Along with the transfer deed, letter of allotment should be submitted instead of share certificate. Yes, if share certificate is not in existence, yes or no? Yes, no. But no. Let's say transfer deed. Transfer deed, which transferor and transferee signed it in form number SH4. This is lost. This transfer deed is lost. This has to be submitted to the company within 60 days. Yes, from date of the signing. Yes, but this transfer deed is lost, or um submitting it submitting it after the period of 60 days. Submitting it after the period of 60 days. Okay, either of the situation. Either of the situation, what to do? What to do? Should company trust, for example, let's say a person y is coming and the y is telling, I lost the transfer deed and now I lost the transfer deed. Please give me what? Please transfer the securities. Sorry, not give me. Please transfer the securities. And companies transferring the securities. Okay. But actually, X is the owner, and X has never transferred it at all. X didn't make a transfer at all. So what? Then will company be in some loss? Company will incur some loss or damage, yes, because what they have already done it, then they are also again going to what, put this name in the put the securities in the name of X. There will be some loss. So company don't want any don't want any problems. So what company is saying? Listen. Why you lost the transfer, you lost the transfer deed. That is your mistake. Okay. For that, why you give me an indemnity bond. You give me an indemnity bond. What is an indemnity bond? We'll see this in Contract Act. We'll see this in Contract Act. I'll tell you simple. As we just saw, what company will have some problem, company will incur some loss. What some X will come and tell that I never transferred. The company said, I don't want any problem like that. Tomorrow, because of you, I'm incurring any loss. You gave the indemnity bond. You gave the indemnity bond. So from you, I can recover. From you, I can recover the amount. From you, I can recover. I can recover the amount. Yes, company can recover from Y amount. Yes, by giving, because Y has given the indemnity bond. It's almost. So like this transfer can be made. So as to indemnity bond, indemnity obtained by company, company may register. Company may register the transfer as board may deem fit. If board wishes, come what they will do the transfer. They will do that. They will register the transfer. Yes or no? Sir, yes or no? Yes. No. Let's say let's say transfer deed transfer deed has been given to company by transferor. Okay, transfer deed has been given given to company by the transferor, plus this particular security is partly paid. This particular security is partly paid. Okay. If that is the situation, now what to do? Company will say, listen, company will give what? Company will give what? Company will give a notice. Company will give a notice to whom? First, company will give notice in form number SH5. Company will give a notice in form number SH5 to whom? To transferee. To transferee. So why, by the way, why a company is giving notice to transferee? See, simple. There are a lot of people who don't know this Companies Act and all. Example, AANIM. AANIM don't know what is Companies Act and all. AANIM doesn't know even there is something called as Companies Act 2013. AANIM know one thing. There is this shares, and I can buy this shares. So value is 100 rupees for one share. I'll pay 100 rupees and I will buy the share. That this is the knowledge I am having. AANIM never know that there is something called call up. There is something called paid up. So shares can be partly paid. I don't know anything like that. Okay. No company is saying. So I'm buying, for example, from X. X is transferring to AANIM. X is transferring to AANIM the security. AANIM thought that X has fully paid the shares. Yes or no? Sir, no. Yes. X has fully paid the shares. AANIM is putting in his head. But company is giving me a notice that this is partly paid. Then only AANIM understood. Yes. So company is what? Giving you a hint. Company is giving you a hint. Company don't have to do this, but lawmakers told that let's do this. And give transferee some more information. Yeah. So transferee what? Transfer is giving this notice. Is receiving this notice from the company. Yeah. Now say okay, transferee received it. Company now what should transferee do? Transferee should give a no objection. Transferee should give no objection to the company. I have no objection. What? I have no problem if it is partly paid. This transferee has to give. Okay. Transferee has to give it within. Transferee is giving it to the company. To company within 2 weeks. 2 weeks from receipt of notice. 2 weeks from receipt of notice. Okay. Company is giving it. Okay. Yes or no? Is company? Yeah. So no objection. Transfer is giving to the company. Okay. Yes or no? Is it receiving? Yes. Company is receiving, or transfer is giving what? And no objection. Okay. Yes, they are receiving it. If they are receiving it, what? Transfer will be registered. But no, if they are not receiving it, if they are not receiving within 2 weeks, then what? Still transfer will be registered. Why? It will be deemed considered that there is no objection. For the transfer. It will be deemed that there is no objection for the transfer. Yes or no? So yes or no? Yes. If shares are in demat form, whether there be any share certificate, no. There is no share certificate also. Plus, no need for what? No need for any transfer deed. Okay. Okay. So how will the transfer and all happen? Simple. Company company will intimate the depository that allotment has been made, transfer has been made, and the depository will enter in its register. Depository will enter in its register. Yeah. Yeah. Now, if depository and depository participant, if depository and depository participant has an intention to fraud, has an intention to fraud with respect to transfer, with respect to any transfer, depository or depository participant is trying to do a fraud. If they are doing it, they will be liable under section 447 fraud section. They will be liable under section 447 law of fraud section. Yes, sir. Yes. If a person dies, okay, if a shareholder dies, sorry, if a security holder dies, what to do? What to do? Person obtains, what person obtains? Right to secure. What right to secure? Right to secure the security. Right to secure security. Person obtains right to secure security. So who's this person? Who is this person? He is the legal representative. Yes, this legal representative what obtains the right to secure the security, yes or no? Mother, father, kids, wife, their what? Their husband, their children died now. The legal representative will get what? Will get the security. Will get the security, yes or no? Yes. So what will they do? This legal representative will intimate the company. Yes, this legal representative will intimate the company, yes or no? And what will company do? And what will company do? Company will company will register. Will company register the transfer? Will company register the transfer? Answer is no. Why answer is no? This is not called as transfer. This is called as transmission. This is called as transmission. Why it is called as transfer? See why it is not transfer. See if you want to transfer, there should be a contract which should be entered between two or more persons. Yes, so these two persons should enter into a contract that listen, I am giving my security to this person, and you are giving what? You are giving me consideration. Yes or no? Yes. But in there are two persons, and this person dies. Okay, and this person is the legal representative LP. What? He will this legal so is there a contract between these two? No, there is no contract between these two. He is a legal representative. This legal representative will go to the company and what? And obtains his right. Obtain his right. Yes or no? Yes or no? Yes. No. Uh, if legal representative if legal representative transfers the security. Is it valid? Is it valid? The first is what? He gave the intimation and they have registered the transmission. So he is the holder. He is the holder of the security. So in that situation, yes, you will say it is valid. He can make the transfer. But he's not still the holder. Just say he company did not register the transmission. Company did not register transmission. Okay, till now they did not register transmission. Okay, so in that situation, is it valid? Yes, it's valid. Why it is valid? It will be considered. It will be considered at the time of transfer. It will be considered at the time of transfer that he is the holder. He means legal representative is the holder. Would be considered. Lawmakers has mentioned this. Yes. Yes. No. So the last one. Sir, in case of allotment is having when you have to give a share certificate. When you have to give a share certificate for subscription for a what? For subscription of a MOA. Subscribing MOA within 2 months. If allotment is made, if allotment of shares. Okay, this is the I'm talking about allotment of shares. If allotment of shares is made, then share certificate will be given. Share certificate will be given. This also within 2 months. Okay. Now, how about allotment of debentures? How about allotment of debentures? Simple. Share certificate will be given within 6 months. Okay. How about transfer or transmission of security? How about transfer or transmission of security? Tell me. Within 1 month. Yes. Yes. Within 1 month of intimation or giving transfer deed. Yes or no? We are going to see section 58. Okay. Section 58 we are going to revise. I'm sorry. Section 58 we are going to revise. So what is section 58 saying? That company, be a private company or public company, if they may refuse to register transfer or transmission. Even if either private company's article says that we are restricting the transfer or any other reason. Public company has the securities can be freely transferable still due to any other reason they are telling that we are refusing it. We are refusing it. Then company shall send a notice. Company shall send a notice within 30 days from intimation or transfer details. Then transferee or legal representatives will receive that notice within 30 days and notice will contain what? Notice will contain a reason for refusal. And what will transferee and the legal representative do? If they wanted, they can make an appeal to a tribunal. It's not mandatory. If they wanted, they can make an appeal to tribunal against the refusal to register. Yes or no? Yes. And failure to send the notice. For these reasons, they can make an appeal. And notice of refusal is received. Notice of refusal is received. Then within 30 days for private company, for 60 days for public company. And notice of refusal is not received, then 60 days for private company, 90 days for public company. Yes or no? Yes. Then tribunal will order. Tribunal will order after hearing the parties. What? Either tribunal will dismiss the appeal or tribunal will make an order that directing to register the transfer or transmission within 10 days. Yes. 10 days from the date of the tribunal's order. And by giving direction to compensate for damage incurred by the aggrieved party. Yes or no? Yes. So we even reverse section 57. Yeah. Any person deceitfully personage what as an owner of security, interest of the company, share or warrant or coupon. Then for why is he doing for that? So that he can obtain, or he's trying to, or he's attempting to, even if he's attempting to obtain also, he will be liable for what is he trying to obtain or attempting to obtain? Security, that interest, the share warrant or such coupon, or the owner's money he's receiving or he's attempting to receive. Yeah, then that person will be liable for minimum 1 year or maximum 3 years of imprisonment and fine of minimum 1 lakh, maximum 5 lakh of fine. Yes or no? Yes. We have finished section 59. We'll revise. Without sufficient cause, name of a person is entered in the register of members. Don't know why, but his name has been entered. Or after hearing, or after hearing, after having been entered, is omitted in the register. After having been entered is omitted in the register. The fact that any person who have become a member or ceased to be a member, what default is made or unnecessary delay is made, unnecessary delay take place in mentioning the register of members. Then company or agreed person or member will rectify what? Rectify the register. How will they rectify the register? They will file an appeal to the tribunal or to the competent court outside India. How will we say this is a competent court? No, which is notified by CGS, and this is a competent court only will be appeal will be made only by a foreign member. Tribunal after hearing the parties will order what? Either dismissing the appeal, or order to register the transfer or transmission within 10 days, or by order rectify the register of members, or rectify the records of depository and pay the compensation for any damage incurred. Next, by any person transferring the securities, that person has contravened the provisions of SEBI, SCRA, Companies Act, or any other current law. Then that the appeal should be made to the appeal will be made to the tribunal by whom? Depository participant or company or security holder or SEBI, and tribunal will direct company and depository holder to first make right the contravention and rectify what? Register of members and records of depository. So no, yes. Last point. What is last point? What is last point? Security holder. Security holder. Does his rights being affected to transfer the security? No. He can transfer the security, no problem. This section will not affect it. Next, the person who's acquiring the security, does he have any problem with respect to voting? Yes, only and only when tribunal suspends the voting. Unless that you can do the voting, yes or no. So yes or no? Yes. No. Now another very small topic. Transfer. Transfer and transmission. Transfer and transmission. So right, what is transfer, what is transmission. So what is transfer? Let's say in our example, A is transferring to B. What is says? A is transferring to B. This is called as transfer, yes. So transfer takes place in an individual capacity. Transfer takes place in an individual capacity only when the transferor wishes B can get it, and only when B wishes B can accept the shares, yes or no. So it is happening in individual capacity, yes or no. How about transmission? How about transmission? Transmission takes place where transmission takes place when due to operation of law. Transmission takes place during operation of law. Yes or no? Transmission takes place during operation of law. So yes or no? Yes. No, no. So what is the operation of law? What is the situation? Either during death, so either during death or either when he is insolvent, either he is when insolvent or either when he is lunatic, either when he is lunatic, yes or no? Yes. No. When transfer takes place, do you think that consideration will be given? Yes. Generally, if you see, consideration will be there. If it is a relative and all, or sometimes consideration won't be there. Yes. But for transmission, is there any consideration? No consideration. No consideration, yes or no? In case of death, who will get it? If in transfer, if we say A is giving B the shares, B will give consideration, yes or no? But in case of death, legal representatives will get it. In case of insolvency, official receiver will get it. In case if he is lunatic, court will give it to the administrator or someone. Yes or no? Yes. So no consideration is required. In case of if shares to be transferred, do you think that if is transfer deed important? Is instrument of transfer or transfer deed is it important? Yes, it's important. Transfer deed is important, yes or no? Yes. In case of transmission, is transfer deed is important? No. Only you have to intimate. You have to intimate the company that this particular shareholder died. I'm the legal representative. Yes or no? So no transfer deed. No transfer deed. Yes or no? Yes. So for this transfer deed, stamp duty has to be paid. For this transfer deed, stamp duty has to be paid. For this, no stamp duty. For this, no stamp duty. So yes or no? Section 61. We are going to revise first. We'll revise section 61. So what is section 61 saying us? That company which is having a share capital, if it wants to alter, it have an ordinary resolution should be passed for it to change the memorandum, and also an article of association also should authorize it. And in section 64, you have to give notice to the registrar within 30 days in form number SH7. And what are the ways you can alter the share capital? One is you can increase the authorized share capital by such amount as it thinks fit, as a company thinks fit. Next is convert all or any of its fully paid up shares into stock, or reconvert its stock into fully paid up shares. Reconvert its stock into fully paid up shares. Yes or no? Yes. Next, consolidate and divide all or any of its share capital into shares of larger amount. But you have to consider one thing, that if the voting percentage gets changed, then you have to get the approval of tribunal. For you to get the approval of tribunal, you have to also make an application to the tribunal to do that. Yes, yes. Next, if you are subdividing the shares into shares of smaller amount, then what you have to do? The paid up and unpaid. The paid up and unpaid should remain the same. Yes or no? Yes. And if you are cancelling the shares which have not been taken by any person, or which also not have agreed to be taken by any person, then how will you cancel it? By diminishing it. Yes. Then this so-called cancellation is not considered as reduction of share capital. Yes or no? Yes. So what are we going to see, sir? We are going to see section 62. We are going to see section 62, where we already saw the section 62 subsection 1 clause A. Yes. So we are going to see the rest. So what we'll revise what we have already seen. If company has a share capital and company wants to increase its subscribed capital, what will company do? Company can issue further capital. Yes, then how will in section 62, what is it saying? You can either do by right issue, you can either do by ESOP, employee stock option scheme, or you can either do by preferential issue. Okay. So we'll see section 62 subsection 1 clause what is with respect to right issue. Company, if they want to issue further shares, if it is a right issue, they can make an offer to the existing shareholders. And they are making an offer to the existing shareholders in proportion to the paid up share capital of the company. Yes, yes. And company want to let the existing shareholders know that they are making a right issue, so that so that the existing shareholders can accept or reject the offer. Accept or reject the offer. For that they will send a letter of offer. So that they will send a letter of offer. Yes, this letter of offer will contain what? Now how many number of shares for the existing shareholder is being offered, that will be mentioned. Then the time limit within which you have to accept. Who has to accept? These existing shareholders has to accept 15 days or prescribed days or maximum 30 days. Yes, and prescribed days is 7 days. Yes, from the date of offer. No. Stay, and also in the letter of offer, the statement will state, what will the statement state, that if you have not accepted it, it will be deemed as it is declined. It will be deemed as it will be declined. Then what the existing shareholders have the right to renounce. Existing shareholders have the right to renounce the shares offered. Yes, to any other, in favor of any other person, unless article of association otherwise provide. Notice, the notice, which is letter of offer, this has to be dispatched. When it has to be dispatched, 3 days before the offer. 3 days before the offer, opening of the offer, you have to dispatch it. And how are you going to dispatch it? By registered post, by speed post, by courier, by electronic mode, or by any other mode where proof of delivery is there. Next, existing shareholders have declined it. Existing shareholders have declined it. Board of directors want to dispose it. Now, board of directors want to dispose in a way where it is not disadvantageous to the company and members. So, how will they dispose it, which is advantageous to the company and members, by allotting to any other member? Yes or no? Yes. But today, anyway, we are going to complete section 62. So, issue of ESOP. So, if it is listed, then SEBI guidelines should be followed. If it is unlisted, then Rule 12 should be complied. So Rule 12, who and all are the employees? Permanent employee of the company, director, whole-time director or not, employee who is working in a subsidiary company or holding company. These and all are the employees we all also saw in 20 degrees here. But for this, even independent director also will not be considered as an employee, and there's an exemption. What is an exemption? The employee does not include a promoter or group of promoters or director relative of any body corporate who's holding more than 10% of the equity shares. Yes, but this exemption will not be applicable to a private company which is a startup and they have not crossed more than 10 years of incorporation. Yes, yes. What are the following conditions to be satisfied if you want to have if your company wants to give a ESOP to employees? First, you have to give what? You have to, if you are giving it to the employee of the company, pass a special resolution. But if you are giving to employer of holding company or subsidiary company, then make a separate resolution. Or if you are giving to an employee at one time, for 1 year, you are giving more than or equal to 1% of the issued capital. This issued capital will not include conversion into shares or will not include the outstanding warrants. Yes, yes. For this also passes by a separate resolution. Then variation in the ESOP. Company, if they want to vary ESOP, there are three conditions to be satisfied. One, what is one? They should not have exercise. They should not have exercise at the option. What is second option? It should not be disadvantageous to the company. It should not be prejudicial to the interest of the employee. Yes or no? Yes. That means it should benefit the employee. What is third one? You should have passed special resolution for this. Next, notice of special resolution. What? That why are you changing the variation? So for that you have to give the details of the variation. You have to give the reason justification for it, and who and all are the employees you have done. These information have to be disclosed. What are the terms of ESOP? Company, if they are granting ESOP, they have to determine what the exercise period, what is exercise period, and they can also specify what lock-in period. So company, what it is the freedom of the company that employees can't say this is the exercise period, 3 years you have to give, and no, that is company's desire, and also will specify you employee you cannot transfer this for so many years, that is called as lock-in period. That is also the freedom of the company, yes or no. And there should be a gap. There should be a gap between vesting of option and granting of option, which is vesting period should be what? Minimum 1 year. Yes. And if it is if company is in merger or amalgamation, where the company which is merging or the company which is amalgamating, the particular company would have told that ESOP they're giving it, and employees would have work for work for some months or years. Yes, that period should be adjusted. That should be adjusted against the vesting period. Yes or no? Yes. An employee shall not have the right. Employee shall not have the right to receive dividend, to do the voting, or any manner which is benefiting benefiting from the shares. What? Till option is exercised. Till option is exercised, you cannot what? Get all the benefits. Next, amount payable to employees. Amount payable by employees. What? At the time of grant of option may be forfeited. Why it will be forfeited? If you are exercising the option after exercise period, or it may be refunded by because of non-fulfillment of the conditions of ESOP. Yeah. Granting and vesting of option. So first, option granted to employees. You cannot transfer it. You cannot transfer it to any person, which means you cannot renounce like right issue. Next, this right cannot be mortgaged, pledged, hypothecated, or alienated in any manner. Yeah. Then which employee company has given this ESOP, that particular employee only can exercise the option. There is an exception to this. What is the exception? First exception. I mean, there's only one exception. That is the person to whom the company has given the ESOP, that person dies. So that vesting option will be given to whom? Legal heir or nominees. Next, if there is incapacitation, if he is permanently disabled, so then in that case, on that date, those particular option will be vested in that person. Yes. On date of resignation or termination, you have to see whether the vesting period is over. If the vesting period is over, the employee can exercise the option. If the vesting period is not over, such as 3 years is the vesting period, in 2 years itself he went away. You have to work for 3 years later, 2 years of itself he went away, which means he cannot exercise the option. Yes or no? Yes. And you have to also mention the explanatory statement and annex with the notice and director's report also. Yes. So the few information has been mentioned that has to be given. Next, register of ESOP, that should be in maintaining form number 6 at the registered office or any other place where board decides, and it has to be what? It has to be entered immediately on exercising it. It has to be entered, yes, immediately forthwith. And that particular register has to be authenticated by a company secretary or any other person authorized by the board. Oh, this is called as ESOP, section 62. So issue of preferential offer. Rule 13. Company, if they want to issue shares or other securities, they will what? They will select some person or group of person, and on the basis of preferential or on preferential basis they will issue it. But because it is on preferential basis, it cannot offer through public issue, right issue, bonus issue, ESOP, sweet equity shares or foreign securities. Yes, but this can be either for cash or for consideration other than cash. And this may or may not include existing shareholders or employees. Shares or other securities will include what? What does it mean? Equity shares, fully or partly convertible debentures, or any other securities which on later date may be converted into equity shares. Company, if they want to issue preferential offer, what they have to do? Yeah, if it is a listed, if shares or other securities are listed, SEBI regulations should be satisfied. Otherwise, if it is unlisted, Rule 13 should be satisfied. what article should be authorized, special resolution should have been passed within 12 months from the date of passing special resolution. You have to make the allotment complete, and price should not be less than price determined on the basis of valuation report prepared by the registered valuer. And you have to complete chapter 3 along with the section 42. Yes. Next, price on convertible debentures. Price on convertible debentures not earlier than 30 days. You don't have to determine, and it should be on the basis of valuation report of the registered valuer at the stage of offer, or not less than 60 days of the date when they can make conversion. Preferential offer of shares, if they are made, if it is for non-cash consideration, then how will you account in the books of accounts? Simple. If it is a depreciable or amortizable asset, carried to balance sheet, otherwise go to it expense in the profit and loss account. If company may allot shares on conversion of debentures or loan into shares only if the terms of issue or as contained such conversion, and special resolution is passed before the issue. But if terms of conversion is not, if the term does not include such conversion, then what to do? Can you issue it? No, you cannot issue it. But you have received that loan or debentures from the government. Okay, from the government, the transaction has been loan or debentures. The transaction has been done with the government. Then government can direct it. Second, it should direct public interest. But before directing it, it will consider 4 things. What are the things? Financial position, terms of issue, rate of interest, and other matters. And if terms is not acceptable by the company, he can make an appeal within 60 days of communication order. Yes, and tribunal will either order it or may dismiss the appeal. Government order to the conversion. Government order for converting shall be made when there is no appeal, or if appeal is made, it has been dismissed, but it is increasing the authorized share capital. Alter the MOS or noise. 68. First we revise section 68. Yes. What is buyback? How can you do buyback? A company, if they want to own their buy their own, purchase their own shares or other specified securities. What is this other specified securities? ESOP and any other securities which CG may notify. Yes, those are the other specified securities. If they want shares and other specified securities to be bought, they can be bought from free reserves, securities premium account, or issue of proceeds of issue of shares or other specified securities. But it should be of earlier issue, but of not of same kind. Yes. Now, for this, article should authorize it. Then special resolution should be passed. But if you pass board resolution, you don't need to pass special resolution, provided 10% or less of the total paid up equity share capital and free reserve will be included. Free reserves includes securities premium account. Buyback is but if you pass special resolution, you can only buy back 25% of the total paid up share capital and free reserves. Yes. And how many number of shares can you buy back? 25%. 25% of the paid up share capital. Yes. And in the explanatory statement, what will be there about all important factors, and what are the class of shares you are going to buy back? What is the necessity you're buying back right now? What is the amount of buyback, and what is the time limit? And debt equity ratio should not be more than 2:1 after buyback. Yes or no? CG may order a certain class of companies to what? A certain class of companies for increasing the higher ratio of debt equity ratio. All shares which are to be bought back are to be fully paid up. Buyback. If those securities are listed, if the shares are listed, then it will comply what? It will comply SEBI regulation. Otherwise, you have to comply this central government rules. Buyback shall be made after the expiry of 1 year. So previous year you have taken a buyback, you have to wait for 1 year. You have to wait for 1 year, then only you can do the buyback. Okay. You have waited for 1 year, now you're doing the buyback. Now you are doing the buyback. When you complete the buyback, completion will be within 1 year from date of passing of resolution. Either it be board resolution or either it be special resolution. Buyback can be from either from existing shareholders. It will be on proportional basis, or in case if it is a listed company, from the open market, you'll buy from a recognized stock exchange, or you will take buyback from that recognized stock exchange, and from the employees under employee stock option scheme or sweet equity shares. Yes. Offer for buyback. What is the minimum period? Minimum period is 15 days. What is the maximum period? Maximum period is 30 days. In between this, shareholders can what? Shareholders can come, and in between this, company will first set the date. Within this period, you have to come and buy back, and shareholders will come and give the shares to the company. And if you want, you can reduce even below 15 members. But there's a problem. What is the problem is, all members should agree with it. All members should agree with it. Then only you can do. If you want to file ROC, if you want to file with ROC, it's not optional. It is mandatory. You have to file. What and all will you file? You will file letter of offer, and you will file declaration of solvency. Letter of offer will contain what? It will be in form SHA. It will be in form SHA. It will be dated. It will be signed by at least 2 directors. 3, 4, 5 it can happen, but at least one managing director should sign it. Then you have to dispatch to shareholders. But it should not be later than 20 days from date of filing with ROC. Then letter of offer should contain what? Letter of offer will contain the information which is true and factual, and director will state that what and all information is there in letter of offer, I'm completely responsible. And what will it not contain? It will not contain any misleading information. It will not contain any misleading information, and it will confirm that we'll open a separate bank account, and adequate fund will be there, and payback will be after payback paying will be made by way of cash. Declaration of solvency. Declaration solvency will be filed with the registrar, and if it is listed, then it will be filed with SEBI also. It will be in form number SH9. It will be signed by at least 2 directors. One shall be the managing director, and it will be verified by an affidavit. It will be verified by an affidavit. Yes. What will he state? He will say that board of directors. What will the affidavit state? Board of directors has made a full inquiry on the affairs, and for 1 year from the date of declaration, 1 year, the company will be at least solvent. Yes. Company will make the verification of what and all offers have received for buyback. That will be verified, and it will be verified within 15 days. It will be verified within 15 days, and where the offer, where company has made a buyback offer, what if you want to reject it, you have to make a communication of rejection to the company. Otherwise, within 21 days, it will be considered as deemed acceptance. Company after date of closure of offer. Closure of offer only they will open a separate bank account. Then they will deposit the fund. Yes, sir. Yes. Company within 7 days. If they accept the offer within 7 days, they will pay cash. If they don't accept the offer, they will return the share certificate. Either they will not accept it partly or fully, and they will return with what? Return the share certificate to the shareholder. Company within 7 days will physically destroy the share certificate for the shares which are bought up. Register will be maintained in form number SH10, and it will be maintained at the registered office. And custody and authentication of the entries made, who will make it? It will be made by the secretary of the company or any other person authorized by the board. And register will contain what is the consideration paid for the buyback, and what is the date in which it is physically destroyed, other prescribed particulars, and company will file return. Company will file return in form number SH11 with the registrar and SEBI. After buyback, company will not make any further issue for a period of next 6 months. But there is an exception for this. What is the exception? What is the exception? Bonus shares and conversion. Conversion which is subsisting, whereas a subsisting obligation for them, then company can issue that same kind of shares, yes or no? They don't have to wait for 6 months. From passing of special resolution to the date of closure of offer, there is no issue to be made. Even bonus issue cannot be made, but you can make, there's exception, conversion you can make. Yeah, the company makes default in section 68 and SEBI regulation. Company and officer default, minimum fine 1 lakh, maximum 3 lakhs. Section 69, yeah, where you have bought the shares from free reserves or securities premium account. Nominal value of the shares will be transferred to capital redemption reserve, and this capital redemption reserve will be taken only and only for bonus shares. Yes, sir. Yes. Yeah. So what are we going to see? So first we'll revise section 67. So company having a share capital, company which is having a share capital cannot just buy their own shares and hold it. No, they have to, if they want to do the buyback, they have to physically destroy it. Yes or no? Yes. Public company, if they are issuing shares, it should not be in a manner. It should not be in a manner where they are giving financial assistance and then they are telling that first if you want you buy my shares, but also I will give you financial assistance. No. This is the financial assistance shall not be given to the person who is going to purchase or subscribe the company shares or holding company shares. And the financial assistance can be by way of loan, guarantee, or security. Yes or no, providing security. This provision will not be applicable to a banking company whose ordinary course of business is lending money. Yes. And next, financial assistance. Financial assistance, the company can give it to the two persons which benefit the employees. So they can get their financial assistance, and they can even purchase companies or holding company shares. Who are those? First is trustee. Trustee will hold the shares in behalf of the employees or in benefit of the employees. Okay, and this trustee can purchase fully paid up shares of company or holding company. But but for that you have to comply two things. What are the two things? One, CG have provided a scheme. That scheme should be complied. And next is central government rules. The third condition is you have to approve the scheme by passing a special resolution. Okay. So what did CG mention any rules? Did CG mention any rules? Yes, CG has mentioned the rule. What is the rule saying? That if the shares are listed, then you have to purchase it from a recognized stock exchange. But if shares are unlisted, then price has to be determined by a registered value. And what is there a limit? Yes, there is a limit. 5% into aggregate of paid up share capital plus free reserves. That is the maximum limit a trust can purchase. Do the purchase. Next is who can be a trustee. They didn't say who can be a trustee, but they have mentioned who cannot be a trustee. Who cannot be a trustee? Who's holding 10% or more of the company shares? He cannot be the trustee. Next is cash company, holding company, associate company, and subsidiary companies. Director, key managerial person, promoter, or the relative of above these person cannot be an trustee. Next. Company is giving loan to an employee. And the employees employ. And what is the limit that company can give? What is the limit of the loan company can give? Maximum 6 months of salary of wages. Maximum, so that the employee can purchase a fully paid up shares of the company or holding company. This particular section 67 is not applicable to private company. In which case, sir, where the body corporate has invested in the share capital of the company, then this particular this particular section 67 is applicable. You have to make sure private company has to make sure that no body corporate has invested. Then only section 67 will not be applicable. For second point, borrowing from banks or financial institution or any body corporate is less than twice of paid up share capital plus free reserves. Less than paid up share capital is twice of paid up share capital or 50 crores, whichever is lower. What is the third condition? That no subsisting default is there with respect to the borrowing. These three conditions, if they satisfy, then this section 67 is not applicable to a private company. If company contravenes section 67, then fines will be applicable to company and every office and default, minimum 1 lakh, maximum 25 lakhs, and every office and default will have may have what? An imprisonment up to 3 years. What is section 70 saying? That company shall not do a buyback in case what? If default is made in repayment of term loan or in repayment of deposit and the interest of term loan or deposits and payment, and if there is a default in payment of dividend, or if there is default in redemption of preference shares or debentures. Next, or the buyback is being done through a subsidiary company, then this buyback is not possible. Or any investment company or any group of investment company, then this buyback is not possible. Buyback, if there is a non-compliance in section 92, section 123, section 127 or section 129, then buyback is not possible. Yes, this is what we have seen. Yes. So through the link given below, you can get this. You'll be getting this website. This is my website. And if you go through the courses, if you click the courses, CA Intercorporate and Other Law. This one is in English only. If you can see, one is in English only. Next is in Tamil and English mix. Okay. So which one are you gonna select? Either English only, the language, or English and Tamil mix. By clicking this, now let's say I'm choosing English only. Now the mode, let's say Google Drive. I have chosen Google Drive, and exam is for November 2023. Exam is for November 2023. The price is 699 rupees. The price is 699 rupees. Through this, you can purchase it. Let's say I want for May 2024. It is 999 rupees. But if you want pen drive, and you are choosing November 2023, it is 1499 rupees. But if you want for May 2024, it is 1799 rupees. And my recommendation is go for a pen drive, because there are topics which you have to download. My recommendation is go for a pen drive. That is much better. This is how you have to purchase it. Okay. Okay. This is how you have to purchase my classes. Now, if you see the books, click on books. There are two things. One is my main book. Next is my summary book. Even if you click main book, let's say you're clicking the main book, you're getting three options. One is Google Drive pen drive. Next is language. You want whether English language or you want English and Tamil, where I'll be explaining you in Tamil language. Or you want the exams, let's say November 2023. You can either select it from the courses if you want my classes, or you can either select it from the book. You'll be getting this regular book and you'll be getting the classes. Let's say you have chosen Google Drive. The price is 699 rupees. This is how you will select my you can buy my course. Let's say you want, along with this main book, you want my summary book. So you are clicking my summary book, where you see it is 899 rupees. It is 899 rupees. This helps. This I have made sure that this is easy and better understanding, and yeah, it contains flowchart, bullet points, so that it is very easy for you to remember and present your paper in your examination. So thank you.